Hello, my name is Jo Rogers. Welcome to this first video in this series. My guess is if you work as a mentor, a coach, a strategist, or an advisor, and you want to sell products or services online or through your events, then the chances are that you want to stop swapping your time for money, and selling online gives you the freedom you desire to make the income that you want. You may also love creating content and sharing that content with others. Perhaps you're already on the ascent and you're scaling a business fast. Perhaps your events are getting bigger and bigger, and there's that niggling part of your brain that says, I should probably know a little bit more about what else I need to do. Maybe you're looking at protecting yourself so that no issues come up to bite you. Or perhaps you've already been burned. Someone didn't pay you for their membership program, or they cancelled on your one-to-one last minute, or you took legal advice and told you that they had a claim and you just didn't really know. Or you've had an ongoing upset with a client and it's forced you to look at how you deal with those issues. Now, I have to admit this is a big topic. When I work with a client, I have to go through their current process and the procedures. So this will be more generic and a lot higher level than that. But I hope that you will get a sense of the questions to ask yourself to see if there are any big red flags, as I call them, in what you currently do. My intention today is that you get an understanding of how it all fits together according to my experiences working with my clients. In this video, we're going to cover 7 core mistakes so that we're all on the same page. You may want to take notes or jot things down, so if you don't have a pen and paper, then perhaps press pause and come back to this video when you have one. So let's begin. The first mistake people make is having a resistance to proper contracts. This shows in people's eyes when we're going to talk terms and conditions. It's that glazed over look that says contracts are boring, agreements are just administration. I do understand that you want to love what you do, and you may not love putting together clear contractual agreements. So I'm going to spend a few moments helping you in some small way to fall in love with your terms and conditions. It starts with removing the resistance to getting this done in the first place, which needs a bit of a reframe around this process. So here are 3 good reasons to fall in love with your agreements. Number 1, because a written agreement sets clear boundaries within any relationship. In theory, an agreement is just a paper-based 2D representation of a small part of the relationship that you have with your client. Stravinsky, a Russian composer, is credited with saying, "Give me boundaries so I can be free." For me, this is one of the simplest reasons to have an agreement in place. In any relationship, do you feel safer when someone is clear with you about their expectations and promises? Do you feel more clear when they are direct with you or when they beat around the bush? Well, when you get married, there are vows, promises that you make that sets out the general terms of how that partnership will be, to have and to hold, for better or for worse, in sickness and in health, till death do us part. An agreement is just that. It's both people saying, I will do this, I will not do that. I will be responsible for this, I will not be responsible for that. I promise that I will do this, I promise that I will not do that. It's basically a division of responsibility. In this scenario, when you are the one providing the services, you get to write the agreement. And so you get to define what you will be responsible for. Don't you see? You determine the game rules. You set the boundaries, you are the one in control. If you just take someone else's terms, for example, you're playing by their rules and their expectations about how you're going to work with your clients, and that just doesn't give you freedom. Any written agreement is just setting out the boundaries of a relationship. It's allowing both parties to look at that relationship in black and white and make a decision whether that relationship is for them. Do they feel safe? Do they want to continue? It gives people a choice. In particular, it gives your clients a choice. Do they want to deal with you on the terms that you're putting to them? Or it gives you a choice. Are you willing or prepared to break your boundaries for a client that wants to work in a different way? I have to be careful here making general statements, but in theory, within the law and within reason, you can do pretty much anything that you want in a written agreement. And so it's a canvas for setting out how you want your client relationships actually to work. Be warned, if an agreement is too one-sided, then you'll put customers off. Make the boundaries too flexible though, and at best you'll be running around in circles and you'll be providing more to that person than you intended. The second mistake after falling in love with agreements is that each signed agreement actually means a contractually committed person willing to sign up to your services, otherwise known as a sale. Recording sales is important if you ever want to sell your own business. You can evidence your client base by the contracts that you store and those that you have delivered on. Rob Goddard from Evolution CBS told me recently that a good contractual base is a powerful reason that buyers want to buy your business. So it could have a benefit in the future. Finally, the third reason is that written agreements save you time and money. For those of us that hate wasting time, there are time management benefits to getting documents signed and stored properly. The Wall Street Journal reported that an average US executive wastes 6 weeks per year searching for misplaced information. Clutter and disorganization of all forms robs you of energy, but it also makes you look unprofessional when those key agreements can't be found when you need them. If your documents are not properly signed, collated and filed, then you can waste valuable time that could be better spent growing your business. Now let's move on to the second mistake I see being made in the industry. Having a signed agreement with all of your clients is really important. If you had to show that all of your clients had an agreement in place, could you do it? If one of them refused to pay, could you show that they had agreed to your terms of business? Do you have those agreements stored with physical signature or one of those tick boxes online? Showing that your client has actually accepted your terms is a critical part of your sign-up procedure. It's not just to demonstrate that you have an agreement, but also when people actually sign a legal agreement, there is a level of commitment and thought process that goes into it. It therefore not only commits them legally, but psychologically as well. In fact, I would suggest that you didn't start working with someone until they had actually accepted your terms of business. Since you'll want that commitment for the work that you're going to do. For one-to-ones, you'll want to make sure that you get what's called a wet signature or a pen signature from your client. In this past, this has actually always had to be on paper, but nowadays you can use software products like EcoSign or online sign-in packages, they can help you to send, manage, record digital signatures for larger number of agreements. These software packages allow you to avoid the hassle of printing, managing, and storing each agreement in a centralized way. We've compiled a list of a few of these automated signature software packages, and you can find a list on our website and you can download that. We don't recommend any of them, but it is a useful list. Getting a physical signature for one-to-ones is actually quite easy to do because there are few one-to-ones that you can do and there's not too much work involved. However, physical signatures are not always an option when it comes to events, unless you have a sign-up team at the front of the room or on reception. So how should you best sign people up to your terms when you're holding an event? The problem is that when you're dealing with events and you have 50, 100, 1,000 people at a time, you're really looking at crowd control. And the more automated and systemized your terms, the better. You can't have someone at the entrance to your event negotiating terms with people that want to come in. So they will have to be standardized and non-negotiable because they must work at scale. Most sign-ups for free or low-cost events are done through an event system, perhaps Eventbrite, and you can add terms of business into Eventbrite if you choose. Where an event may be emotionally or physically challenged, we have seen clients asking for all participants to sign a health questionnaire and a declaration that they're fit to attend. Sometimes this is appropriate, but you'll have to judge that based on the contents of your course and its content. What feels right, be guided by your personal taste, and be guided also by the norm in the industry. From a client perspective, you will get direct feedback on what works and what doesn't. You will not want to overkill and drive your clients away from events. If you overdo it, that is what will happen. As an aside, regardless of whether you have terms that are accepted, you will at a minimum want to remind people about health and safety for the venue, confidentiality within the room, remind them that there are speakers that are not from your organization, and ask them not to take photos or make recordings. Tell me this, have you ever bought anything online and ticked that box saying, I've read those terms and conditions, but not actually read the terms and conditions? Do you remember how easy it is to do that? I've done it too. In short, sometimes we forget that ticking that box without actually reading the terms and conditions is exactly the same as signing a physical agreement without reading it. Assuming that there is no fraud or misrepresentation by you, your client will be deemed to have expressly agreed to any terms if they tick that box. And terms that are going to be online are also not negotiated. Now, this isn't intended to trick anybody and certainly isn't intended to be devious, but there are benefits to getting people to signing up online. If you have to get acceptance from lots of people and keep track of who has agreed and who hasn't, then this is a quick and pain-free way of doing that. I've heard of people using the similar procedure for sign up for events, and that does reduce paperwork and helps the process. Now we've looked at getting agreements signed, the question is, which terms of business actually now need to be signed? This is mistake number 3. In this industry, I invariably see people with the wrong terms for what they want to do. In an ideal world, each of these agreements should be aligned or have at least similar terms to the others. The reality is always somewhat different. We're going to take this section to walk through the terms of business that you'll probably want in place in this type of business and a brief look at the differences between them. The first terms that you will want are those on your website. They're privacy terms and terms of use. These are simple and easy to write. They can usually be found on most template websites, or go to our website and copy them from us if you like. They are in pretty much a standard format. They will state how you will look after someone's information when you receive it, what cookies are for, and the expectations that you will have when someone else uses your website. I have seen people try to use these terms for an online membership program. That will not work. These terms are too basic for that. It's just for your basic website only. The next agreement will be your one-to-one consultancy agreement. This could be one-off, or it could be on a block of one-to-one sessions. This will usually cover any guidance provided, and in our next video, we will let you know 3 of the most important core terms you need in those terms to keep you protected. Now let's look at training or workshops. If you're going to someone else's place of work to deliver workshops or training, then the process will again be slightly different to your one-to-ones. This will be reflected in your terms of business. You may commit to training a certain number of people over a certain amount of time or on a particular topic, and you may have agreed certain outcomes for one day. In particular, your concern may be them cancelling on you last minute, so you'll want to make sure and be clear that you're prepared to re-deliver a course, but you won't provide a refund. You may also have a membership program that's offline. These terms will differ because a membership program usually spans a longer period of time than a block of one-to-ones. In a membership program, there are a mixture of workshops, events, online memberships, and one-to-one sessions. You'll either want to make sure that every participant signs up to the term for each type of session, or make sure that they're all cleverly weaved into one document so that they just have to sign them once. Then you may have an online membership program or a community. This differs from the offline membership program because these clients will have access to products and downloads, usually through a membership key. Again, there will be separate terms for this that will probably be signed up to when they log into the program and will include things like keeping their passwords safe. Perhaps there's a retreat that you're going to create, and again, similar terms can be used, but you need to adjust it so it links to a booking form with terms of business, and it needs to then be clear who pays for travel, what happens if there's a cancellation of flights, things like that. If you're bringing on consultants, volunteers, or other speakers, you may want something in writing with them, a consultancy or a volunteer agreement. This is especially important for people that are creating any intellectual property for you, such as filming or photography. If they have no written agreement with you, then they will need to transfer the intellectual property in the photo or the film. Otherwise, it will be owned by them, even if you've paid for them to provide that to you. Go to our website and download the event management spreadsheet. Will allow you to separate the terms of business for each of these events and make sure that you know the process that a client will follow when they sign up. It will help you to get clear on the document that you have for which event and understand the acceptance procedures, the payment terms, the refund options, and the services that you're going to be providing to these clients for that event. The 4th mistake that business owners make is to get a lawyer to provide them advice way too early. Lawyers provide wisdom, but they don't always provide affordable wisdom. So in the early stages, when you're cash poor, opt for templates that you know will work for your business and then tidy them up either when there's an issue or when you have some cash for a full review. It's better to get started than to make it perfect. Whilst it's the safest position, taking a legal advice too early can lead to wasted costs. Don't get me wrong, lawyers provide a great balance to your business, particularly if you're a creative or a visionary person, or if you have been in business for a while and you've already run the gauntlet and taken some risks already. But early doors, I'm all for downloading documents when you're small and you have little to lose. A little trial and error is sensible and it reduces your risks and your costs. If you do decide to instruct a lawyer, then I hope this series will give you enough information so you can actually go to them with a plan, which should then reduce those costs. Early stages, I suggest you find a simple telephone help desk or a phone-friendly lawyer to get what you need, whether it's a template or reassurance that a clause works for you. Be smart with your time and money so that you can make the most out of the guidance provided. The more that you can do for yourself at the early stages, the better. The fifth mistake business owners make is to trust every client that wants to work with them. If you love what you do, then you're probably a nice person. Well, you may give people the benefit of the doubt because they're like you, but every now and then you come across someone that doesn't quite feel right. You can't put your finger on it and you want to make the sale, but something in the core of who you are is just saying, don't do it. Now, whether your messages are intuitive or you've Googled the guy and there just is something disconcerting there, my philosophy is simple. Never get into business with somebody that you do not trust, and this especially relates to clients. It sounds like an obvious principle, doesn't it? However, time and time again, people come to me and say, I don't trust this person. Could you make the agreement watertight? Or I knew I couldn't trust that person. There was just something about him or her. How do you know to trust somebody in the first place? Well, sometimes it is just a gut instinct. Other times you do your full due diligence and sometimes it's blindingly obvious, but you'll ignore the signs anyway. For example, I once made the mistake of taking on a client who I had this sense about. Another lawyer had contacted me to warn me not to take him on. There were several allegations online against him and they related to fraud and slightly dodgy dealings. It didn't feel right. It didn't feel right from the start, but I was new in business. An introduction from a trusted friend kind of muddied the waters. So I took his word when he assured me that the lies on the internet were all libelous and untrue. They turned out to be true. He failed to pay, and in the end, we were thousands of pounds out of pocket. If you don't trust someone or if something just isn't sitting right with you, then don't bring them on as a client. We all want to trust that people we are dealing with are honest and reliable and that they'll pay their bills or do what they say they will do. But that's not always the case. The sixth mistake is really more of a myth. It's the myth that a watertight agreement will somehow stop you from having to deal with any issues at all. It's a depressing truth for me, actually, that I've learned the hard way. It doesn't matter how long your agreement is, how many terms you've got to protect yourself, but when someone owes you money and they're sticking by the idea that they do not owe you money and they refuse to negotiate with you, the only way forward is to spend more of your own money to enforce the agreement through the small claims court. Watertight doesn't mean pain-free. And unfortunately, it's a problem when you can't afford to take the matter to court. Finally, let's talk storage of documents. Many businesses make the mistake of not properly storing their documents. Once an agreement is signed, you will also want to make sure that it is stored somewhere that is easy to access. The importance of keeping records is so often overlooked, especially in this creative, chaotic entrepreneurial space. This is easier when you're signing people up online because this will be done automatically. When you have paper documents, you will need to make sure that they're not just stored, but also that they're stored securely, since these agreements may contain personal information for these individuals. For all paper copies, make sure that you also scan a copy to yourself and have a backup of your scan in 2 different places. I've made this mistake twice and I was lucky on both times to have an extraordinary brother who could sort it out, but a backup is absolutely key. As consultants, you're privy to a lot of personal data about your clients. They might provide you with written financial details for you to charge their credit card, and at a minimum, you're going to have their name and email address stored somewhere. If you are collecting and storing personal information, then you may want to make sure that you're registered with the ICO or the Information Commissioner's Office. The most important thing to do is to complete the online test on their website. It's ico.gov.uk. And that allows you to determine whether you need to be registered. Registration for small businesses are usually £35 a year, and you'll also find out how you can be in compliance with the data protection regulations on that website. If you leave it to chance, you might be referred to the Information Commissioner, who may impose fines or take legal action against you. So finally, that brings us to the end of this first video in our series. I hope that you've got some value, and I feel like you might be raring to watch video 2 in the series. In our next video, we will get a little bit more into depth into the 3 most important terms that you must have in your written terms of business when you do one-to-ones. And then finally, in video 3, we'll cover how to deal with complaints legally and safely so that you settle matters quickly and you can decide whether to pursue clients that don't pay. I really look forward to seeing you then.